You don't. You don't live around here. You a nanny? Housekeeper?
Officer, this is my neighborhood. I am Judge Elena Whitmore.
Anyone can say that.
On a quiet Thursday evening in Pasadena, a routine drive home would turn into a constitutional showdown that ended with a sitting California judge standing barefoot on her own curb while a police officer insisted she didn't belong in the neighborhood. A moment caught on body camera that would later trigger a $28 million federal lawsuit and force a city to confront what happens when bias overrides badge and training. At 6:18 p.m., Judge Elena Whitmore, 48 years old, supervising judge at the Los Angeles County Superior Court, turned off Orange Grove Boulevard into the tree-lined residential enclave she had called home for 6 years. Her silver Lexus SUV moving slowly past manicured hedges and Spanish-style homes glowing in the last wash of golden light. She had just concluded a long day presiding over a contentious civil rights trial, still wearing her navy suit though her robe hung folded neatly in the garment bag in her back seat, her briefcase resting beside it filled with annotated motions she planned to review after dinner, unaware that 2 blocks ahead Officer Caleb Norris of the Pasadena Police Department had already begun following her, his patrol vehicle idling briefly at a stop sign before pulling out behind her SUV, his body camera activating automatically as he flipped on his overhead lights, the red and blue flash reflecting against stucco walls and trimmed rosebushes in a neighborhood where traffic stops were rare enough that curtains shifted and porch lights flicked on at the first sign of police activity. Whitmore noticed the lights in her mirror and felt the familiar tightening in her chest. Not fear exactly, but the sharpened awareness that comes from decades of navigating spaces where authority and perception do not always align, and she signaled, pulling to the curb directly in front of her own home, the address visible on the wrought iron numbers mounted beside her door, her garage just 15 feet away. She lowered her window before Norris even approached, hands resting calmly on the steering wheel, posture composed, because she had presided over hundreds of suppression hearings and knew precisely how these encounters were supposed to unfold. Norris walked up with deliberate steps, posture stiff, one hand resting near his holster, and without greeting said, "License and registration." His tone flat but edged, and Whitmore replied evenly, "Of course, officer. May I ask the reason for the stop?" A simple, lawful question that in court would be considered routine, but on that curb seemed to irritate him. And after a pause he said, "We've had reports of suspicious vehicles driving through this neighborhood," scanning the houses as if to confirm something unspoken, and Whitmore asked, "What about my vehicle is suspicious?" And Norris responded, "You don't live around here." A statement that hung in the air heavier than the flashing lights, because her driver's license, still in her wallet, listed the very address in front of which they were parked. She blinked once, slowly, then reached for her purse with measured movements, narrating softly, "I'm retrieving my license from my back," conscious of the body camera recording, and handed him the card, watching as his eyes moved from her face to the address and back again, skepticism unsoftened even by printed proof. "We've had break-ins," he said, though dispatch logs would later show none reported in that area in weeks, and Whitmore replied, "Officer, I have lived at this address since 2019, and gestured slightly toward the front door, where a porch light now illuminated her front steps, and a neighbor across the street had begun recording on a phone." Norris did not step back or apologize, but instead asked, "Is this your vehicle?" And when she answered yes, he said, "Step out of the car." And she paused, because she understood the legal threshold for ordering a driver out during a traffic stop, but also understood there had been no articulable violation stated, no speeding allegation, no equipment malfunction, only the assertion that she did not appear to belong. Still, she complied, opening the door and stepping onto the pavement, the gravel cooled beneath the thin soles of her heels, standing upright with her hands visible, and said clearly, "For the record, I am Judge Elena Whitmore of the Los Angeles County Superior Court, and I am standing in front of my home." And Norris responded, "Anyone can say that," before calling for backup, his radio crackling as he requested an additional unit to verify occupant, a phrase that would later be dissected line by line in a federal complaint. Within minutes, another cruiser arrived, then a third, neighbors gathering in clusters, whispers rising, someone audibly saying, "That's the judge who lives there." And Whitmore remained composed, aware that escalation would only feed the narrative forming in the officer's mind. Aware, too, that this encounter was no longer just about her, but about the precedent unfolding in real time. "Am I being detained?" she asked, voice steady, and Norris replied, "We're just making sure everything checks out," though her license already had, and she said, "You have my identification and my address matches this residence. What additional information are you seeking?" A question he did not answer directly, instead asking if anyone else was inside the house, if she could prove residency beyond the license, if she had mail with her name on it. Each request drifting further from constitutional clarity, and she felt the shift from routine stop to something else entirely, something rooted not in probable cause, but in perception. 11 minutes passed. 11 minutes on her own curb under patrol lights while neighbors watched, before a supervising sergeant arrived, reviewed the license, glanced at the house numbers, and quietly instructed Norris to clear the stop, and only then did the tension ease. The lights switching off, the cruisers pulling away one by one, leaving behind the stillness of a neighborhood that would never quite feel the same. And as Whitmore walked up her driveway toward her front door, she turned once more toward the lingering body camera and said calmly, "This interaction will be addressed appropriately." Words that sounded less like a threat and more like a promise, because she understood better than anyone that the Constitution does not bend for suspicion unmoored from fact, and that sometimes the most consequential cases begin not in a courtroom, but on a quiet street where someone decides who does and does not belong. By sunrise the next morning, the body camera footage had already begun circulating online, and what started as a quiet curbside detention in Pasadena was rapidly becoming a national flashpoint. The clip of Officer Caleb Norris telling a sitting judge, "You don't live around here," replaying on local news loops, shared across legal forums, and dissected by constitutional scholars who pointed out the glaring absence of reasonable suspicion. By 9 a.m., reporters had gathered outside the Los Angeles County Superior Court building where Judge Elena Whitmore arrived for work as she always did, composed, punctual, expression unreadable. Though inside the courthouse corridors whispers followed her, clerks and bailiffs offering quiet nods of support, attorneys pausing mid-conversation to glance at their phones where the footage continued to rack up views. The 11-minute stop, once confined to a residential street, had expanded into a public reckoning, and legal analysts on networks from CNN to regional affiliates were already breaking down the exchange frame by frame, noting how Whitmore repeatedly asked for the legal basis of her detention and how Norris never articulated a traffic violation, equipment infraction, or credible bolo description. Civil rights organizations issued statements before noon, calling the stop textbook profiling, while former prosecutors described it as a Fourth Amendment problem wrapped in a public relations disaster. Inside City Hall, the mayor convened an emergency meeting with the police chief of the Pasadena Police Department, and by afternoon Officer Norris had been placed on administrative leave pending internal affairs review, though the department's first public statement characterized the encounter as a neighborhood patrol contact that escalated due to miscommunication. Language that only fueled backlash once full footage contradicted that framing. Meanwhile, Whitmore declined interview requests, choosing instead to do what she had done for decades, build her case methodically. She retained civil rights counsel by the end of the day, and within 48 hours a litigation hold letter was served on the city demanding preservation of all body camera footage, dash cam recordings, radio transmissions, prior complaint histories, training materials, and internal communications involving Norris, because she understood that accountability required documentation, not outrage. Discovery would later reveal that Norris had conducted a disproportionate number of suspicious vehicle stops in majority-white neighborhoods compared to other patrol officers, data that analysts described as statistically significant. Text messages retrieved from his department-issued phone included remarks about keeping certain streets from changing, phrases that, while not overtly explicit, painted a pattern that civil rights attorneys argued demonstrated discriminatory intent. As the footage climbed past 5 million views in under 72 hours, community activists organized a town hall at a local community center, where residents, some who had witnessed the stop, described feeling unsettled that such an incident could occur on a street where children played daily. One elderly neighbor recounted watching Whitmore stand calmly under flashing lights and said, "If they can do that to a judge, what happens to the rest of us?" The question echoed across editorials statewide, reframing the incident from an isolated misunderstanding to a broader commentary on belonging and authority. On Monday morning, Whitmore filed a federal civil rights lawsuit in the United States District Court for the Central District of California, alleging violations of the 4th and 14th Amendments, deprivation of rights under color of law, intentional infliction of emotional distress, and municipal liability for failure to train and supervise, seeking $28 million in damages, a figure that sent shockwaves through municipal budgeting offices and prompted immediate debate among legal commentators about exposure and precedent. The complaint, 47 pages long, cited Supreme Court jurisprudence on unlawful seizure, emphasized that a traffic stop constitutes a detention under constitutional standards, and detailed the absence of articulable suspicion beyond the officer's assertion that she did not look like she belonged. It also noted that backup officers failed to independently verify her identification before prolonging the stop, compounding the alleged violation. As the litigation progressed, depositions revealed troubling inconsistencies. Norris initially claimed he suspected vehicle theft based on a vague radio alert, yet dispatch logs contained no active alerts matching Whitmore's vehicle description at the time. When confronted with the discrepancy, he stated he acted on instinct, a term that plaintiff attorneys seized upon as evidence of subjective bias untethered to objective criteria. Public pressure intensified when a local investigative journalist uncovered prior citizen complaints against Norris alleging similar stops involving minority drivers in predominantly white neighborhoods, complaints that had resulted in counseling memos but no formal discipline, and the narrative shifted from one officer's lapse to systemic oversight failures. The city attempted mediation early, offering a confidential settlement that Whitmore declined, stating through counsel that monetary compensation without structural reform would be insufficient. She sought policy changes mandating documented probable cause entries before initiating vehicle stops, expanded implicit bias training, and independent review mechanisms for profiling allegations. Meanwhile, protests outside City Hall remained peaceful but persistent, signs reading, "Belonging is not suspicion," and "Equal protection means equal streets." And during one council session, residents lined up to speak, urging transparency and reform rather than defensiveness. As weeks turned into months, the city's risk assessment became increasingly clear. Trial would mean public examination of training deficiencies, supervisory decisions, and demographic stop data, all under oath. Legal experts speculated that a jury might respond strongly to footage showing a calm, prudential judge detained outside her own home without stated cause, especially given her repeated invocation of constitutional principles. Whitmore continued presiding over cases throughout the process, never referencing her own lawsuit from the bench. Yet colleagues noted a heightened emphasis in her courtroom on articulating probable cause during suppression hearings, as if the abstract doctrine now carried personal resonance. By the 12th month, negotiations resumed under a federal magistrate's supervision, and numbers escalated as both sides weighed litigation risk against public accountability. Analysts predicted that whatever resolution emerged would rank among the largest civil rights settlements in California municipal history. Throughout it all, the central clip remained unavoidable. The moment Norris said, "You don't live around here," and Whitmore replied with measured clarity that she did. A micro-exchange that crystallized centuries-old tensions about who is presumed to belong and who must prove it. And as legal briefs mounted and public discourse swelled, the case evolved from an isolated stop into a referendum on constitutional policing in modern suburbia, setting the stage for a reckoning neither the officer nor the city had anticipated when flashing lights first illuminated a quiet Pasadena curb. 17 months after flashing lights turned a quiet curb in Pasadena into a national headline, the reckoning arrived not in a dramatic courtroom verdict, but in a packed city council chamber, where officials voted 6-1 to approve a $28 million settlement with Judge Elena Whitmore. one of the largest civil rights payouts in California municipal history, a number that represented not only legal risk but the cost of a moment when an officer decided someone did not belong. The agreement followed weeks of confidential mediation overseen by a magistrate from the United States District Court for the Central District of California, where attorneys for both sides weighed body camera footage, internal emails, deposition transcripts, and statistical analyses of traffic stop data that plaintiff experts argued showed a pattern of discretionary, suspicious vehicle stops disproportionately concentrated in majority-white neighborhoods. City officials initially bristled at the figure, calling it fiscally painful, but trial consultants warned that jurors watching the now infamous clip, Whitmore standing calmly in front of her own home as Officer Caleb Norris insisted she did not live there, might see not a misunderstanding, but a constitutional violation unfolding in real time. The final settlement included more than money. Officer Norris formally resigned from the Pasadena Police Department before the vote, forfeiting eligibility for rehire, and the department agreed to a multi-year federal oversight framework requiring documented probable cause narratives before initiating vehicle stops, mandatory supervisor review of any stop exceeding 10 minutes without citation, expanded implicit bias and constitutional policing training developed in consultation with external civil rights experts, and the creation of an independent civilian review board with subpoena power to examine profiling complaints. At the press conference announcing the resolution, Whitmore stood beside her legal team but spoke first, her tone steady, measured, unmistakably judicial. This settlement acknowledges that what happened on my street was not a harmless error. It was a constitutional failure. The Fourth Amendment is not conditional, and belonging is not determined by perception. She emphasized that while the monetary amount reflected the seriousness of the violation, structural reform was the true objective, explaining that she had negotiated specific policy changes as non-negotiable terms. Reporters asked whether she believed Norris harbored explicit bias. She replied carefully, "Intent can be debated. Impact cannot. When authority detains someone without lawful basis because they are perceived as out of place, that is a harm the Constitution is designed to prevent." Behind the scenes, city attorneys acknowledged that discovery had revealed vulnerabilities they did not want tested before a jury. Prior complaints against Norris involving similar discretionary stops, supervisory emails urging officers to be visible in certain enclaves without clarifying constitutional thresholds, and training materials that emphasized officer safety scenarios more heavily than procedural articulation requirements. Financial analysts projected the settlement would be covered through a combination of insurance reserves and municipal bonds, but the political cost extended beyond balance sheets. Council members who had once dismissed the incident as miscommunication now publicly conceded that trust had eroded, particularly among residents of color who saw in Whitmore's stop a familiar pattern. In the months following the agreement, reforms moved from paper to practice. Patrol vehicles were equipped with updated reporting software requiring officers to input specific, articulable facts before closing a stop record. Supervisors received automated alerts for discretionary contacts lacking citation outcomes. Quarterly demographic audits were mandated and presented at public meetings. And new recruits underwent scenario-based training, simulating ambiguous encounters designed to challenge assumption-driven decision-making. Whitmore, meanwhile, directed $6 million of the settlement to establish the Judicial Access and Equity Foundation, funding legal clinics and scholarships for aspiring public defenders and civil rights advocates across Southern California, stating that access to justice must be proactive, not reactive. She declined to move from her home, telling a reporter that leaving would suggest she agreed she never belonged. On the first anniversary of the stop, the department released data showing a measurable decline in discretionary suspicious vehicle contacts and an increase in documented probable cause articulations, trends cited by reform advocates as evidence that accountability mechanisms, when enforced, can shift institutional culture. Critics argued that no policy can eliminate bias entirely, but even they conceded that the visibility of oversight created deterrence. In law schools and police academies statewide, the footage became instructional material, played alongside case law analyzing investigatory stops, with instructors pausing at the moment Norris says, "You don't live around here," to ask trainees what constitutional threshold was met, a silence often followed by uncomfortable reflection. Whitmore continued presiding over her courtroom at the Los Angeles County Superior Court, never referencing her case from the bench, yet unmistakably more insistent that attorneys articulate clear factual bases during suppression hearings. Colleagues noting that lived experience had sharpened her already meticulous scrutiny. When asked privately whether the ordeal changed her view of the justice system, she reportedly replied, "It reminded me why precision matters." Officer Norris largely retreated from public view after his resignation, his brief statement expressing regret for how the encounter unfolded, but stopping short of admitting discriminatory intent, a phrasing that satisfied neither critics nor supporters. Legal commentators observed that while individual accountability was necessary, systemic change required sustained attention beyond one resignation. A year later, the street where patrol lights once flashed returned to its ordinary rhythms. Joggers passing at dusk, children riding bicycles, sprinklers ticking in evening air. Yet residents described a subtle shift in awareness, an understanding that constitutional principles are not abstractions confined to courtrooms, but lived protections tested in ordinary moments. The $28 million figure would remain in municipal records as a stark reminder that assumptions carry costs, but Whitmore framed it differently during a civic forum months later. The number is significant, yes, but the greater value is clarity. Clarity that no one's legitimacy should hinge on someone else's perception. In that sense, the settlement marked not an end but a precedent, a case study in how a single traffic stop can expose institutional blind spots, and how structured accountability can translate outrage into reform. Because what began as a claim that someone did not belong became, through litigation and policy overhaul, a reaffirmation that constitutional rights travel with you, down quiet streets, past manicured lawns, and onto any curb where authority meets assumption.